I'm going to respond to this point itself.
First point that they are specially trained. This species are, in Tamil Nadu, they have this tradition, and the bulls are being trained.
That is what they have said, that there is a certain type of bull. If your lordship just read the act, your lordship will just see the statute itself. You see the amending statute.
That's right.
And the SOR.
One more thing.
Yes, yes.
Besides Peruncurium, is it any case of a subsilent show? That is also one of the grounds, which can be gone into by taken into account by the higher court.
Subsilent. Sorry, but I didn't follow the question.
You said that normally when a decision is there,
yeah,
the bench of course the more strength.
Right.
Of course, whether they can look into that question.
Yeah.
You said that of course Peruncurium that can be gone into.
Yes.
But at the same time, a case of a subsilation can also.
So let me answer this issue on subsilent. I'll just formulate my answer.
There is also instances where these or can. On that possibility. Besides Peruncurium, subsilation. What's
Yes. So now I'm just endeavoring to answer the question which was put. Let me at least supply my understanding of the law as far as revisiting a decision of this court is concerned. I believe it's absolutely clear on the strength of the decisions I said that there is no intra-court appeal insofar as this. I think that's absolutely clear because that's the Justice Sawant judgment. Please don't just make us an intra-court appeal because you're sitting in a larger combination, etc. So that's out. That's one. The second pillar is that, look, there is a recourse under the Constitution, which is Article 137. And of course, your lordships have created under the Rupa Hura case one more curative scheme if there's some great miscarriage of justice. But even that is a much narrower area than even available insofar as review jurisdiction is concerned. The third element which I want to flag is that because rule of law is so important and the credibility of this court as an institution is also dependent on finality of judgments, there are restricted categories. I'm not saying, I don't think there's any wisdom in defining all the categories available to the court. I think that will have to be kept open-ended. But illustrative of the sort of cases where a larger panel may revisit is a situation. And one is per incurium, which I have made my submission, may not apply over here because the facts and the law have been looked at exhaustively. That's one element. The second question is, and which we pointed out, if there is some completely fundamental error. Now, one of the fundamental errors could have been that, look, where are animal rights? You have mentioned animal rights in your final operative direction is that please give a constitutional rights. What is this notion of animal rights, etc.? It's a fundamental error. The answer is no, that's not a fundamental error. Because the court has very carefully used the expression animal rights in two contexts. One, not because we are saying X or Y or Z or that we are overturning Salmon on jurisprudence. No. There is an express duty which is cast as far as human beings is concerned, and the corresponding element the court has described as a right. That's about it. Not as if there is some right by which an animal can go to court tomorrow and say that please enforce this right. And there are 5 universal freedoms which I have taken your lordships through, so that's the context in which animal rights as a compendious expression has been used to capture these broadly. So there's no fundamental flaw on that as well. Now, if that is not the case, the question I ask myself is, what is the great error in terms of some public cause? Because that may be also, there may be some, see, I think those L. Chandra Kumar, etc. cases which were given to me, which were cited and rightly so, were in case of the entire constitutional machinery in terms of redress. So that is one. Then you have a large number of cases, your lordship recalls, even in the arbitration field as far as section 11 is concerned, two judges, 3, 5, 7. It were kept going up and there were alternate and then there was a legislative intervention. So that also had to do with some fundamental issue insofar as commercial law is concerned, and the court found that it had to correct or fine tune, etc. But there was something fundamental with having huge and enormous public impact. I don't believe those criteria are met over here at all. As far as sub silentio is concerned, my understanding of that doctrine is that you could have certain situations where there is an undercurrent which is running through a judgment which is not completely and fully articulated. Now, I don't believe there is some such articulation over here in Nagaraj which makes it vulnerable. That's my submission. The articulation insofar as Nagaraj is concerned is express. It is right there in the face for each one of us to read. It is very well reasoned and well considered. That's my point of view. And ultimately, whether right or wrong, it doesn't fulfill the criteria in our respectful submission, which would invite an overturning.
Sub silentio operates in the field of precedent.
But it's precedent.
It may not have any application here.
It may not, because yes, as a larger panel your lordships have held, you may be able to rob a smaller combination's judgment of its precedential value.
So it's
yes.
for the purpose of
yes.
Here we are
may not quite arise.
We are not dealing with precedent.
Yes.
Here we are dealing with the question whether the legislature can take away the right.
Yes. That of course on the larger point. Now just have a look at the Act, since your lordship put this to me. The Act itself is at page 137 of volume 1.
Yes.
I'm not taking you through the analysis because Mr. Luthra has already done so, but I thought I'll just point out page 137 of volume 1 of the convenience compilation. An act to amend the Prevention of Cruelty to Animals Act 1960 so as to preserve.
1 second.
Yes, I'm so sorry.
Lighter note, Sham is telling, we are actually never asked the bulls whether they would like to have a run with the human beings. Give it back to them for what they have been doing it to.
There was
an opportunity for them.
There's a famous article, which was a scholarly piece written by an American scholar in, I think, the Yale Law Journal in the 1970s. On should trees have standing? Should trees have standing? And so then he explained it as to why trees should be given standing, which was a question which your lordships also had come up. Let's give them standing so that they can, whatever, forest rights, etc. Then there was I can only describe it as rather cheeky and cute response which came in some Harvard Law Journal or something, where he says exactly what your lordship said. That look, I have a river which has been flowing for millions of years, but I want to be dammed. And then it talks about another mountain slope, I remember, which says, look, I want a ski lift for tens of thousands, millions of years I have had no ski lift, so please put a ski lift, please dam me, etc. But it was meant as a cheeky response. But your lordship is quite right. We cannot. Now, in this regard, there's a whole developing science now on sentient creatures, and I'll cite just one article on that. When you have creatures themselves, now the science is indicating that they are capable of feeling pain. They're feeling, I mean, they're not emotions, complex emotions as you and I would understand that expression. But then what is to be done? So I'll come to that separately. But now I'm answering the question put to me with regard to these traditional, the species of bull. Now just see what their act says, the amending act. An act to amend the Prevention of Cruelty to Animals Act so as to preserve the cultural heritage of the state of Tamil Nadu and to ensure the survival and well-being of native breeds of bulls. Now, I strongly commend to the state of Tamil Nadu, and we support anything and action being done for the well-being of the native breeds of bulls. By all means, as your lordship correctly said, they are worshipped. Of course, they should be worshipped. They are looked after and with the greatest love and care. Yes, please do that. But can you subject them to cruel treatment? As a justification, the answer is no. But now let's see what they have said first. So see the definition of Jallikattu in double D. Jallikattu means an event involving bulls conducted with a view to follow tradition and culture on such days for the months of January to May of a calendar year in such place and may be notified by the state government and include so and so, so and so, so and so. And then your lordships will see the carve-outs which are conducted in the conduct of, please see in 11.3e, the conduct of Jallikattu with a view to follow and promote tradition and culture and ensure the preservation of native breeds of bulls and also their safety, security and well-being. There is not a jot, there's not one line which says that because of that, unless we hold Jallikattu and subject it to all sorts of inhuman and cruel treatment, that this particular native species or breeds is going to be unwell or it is not going to be secure. So what our respectful submission is, there are a huge line of traditional bulls in India, except and obviously cattle, bovine creatures. Those lines, some of them are outstanding. I mean, in terms of, I'm talking bovine, male as well as female, for the purpose, say, as far as milk production is concerned. Others may be very strong animals for the purposes of pulling, etc., and draft animals. Yet others may be have utilities which are otherwise. And you may have utilities and you may want to preserve bulls, etc., and traditional bulls because of their size, because of their beauty, because of their horns, and all sorts of things. So we are not against that at all. Please do so. Please set aside funds. Please create goshalas or whatever you want and preserve these bulls. But that doesn't mean you subject them through a carve-out over here to cruel treatment. That object itself, this is the point, that object itself after a determination of this court is per se illegal according to me. Is preserving your tradition and culture illegal? No. Emphatically no. You may do so. Is preserving a breed of bulls bad or illegal? Answer is no. It is, of course, it is good and in the interest of the bulls and the species, we must encourage it. But is continuing an event which is defined over here as Jallikattu, which has been found by this court and which has been found by these reports as inflicting untold misery on the animals, those specific animals which are worshipped at other times of the years, that is clearly not permissible. It's an illegal object. So anyway, there is nothing here which your lordship will find in the statute itself, apart from these particular, and also in 27, the amendment, the conduct of Jallikattu with a view to follow and promote tradition and culture and ensure the survival and continuance of native breeds. This event is not dependent, the survival of native breeds is not dependent on Jallikattu at all, is my respectful submission. It's absolutely irrational, according to me, and it is manifestly arbitrary. Now, there is also a statement of objects and reasons to the Act, which I'll just place before you, because there's one line in that as well. And I just indicate, it refers to the Supreme Court judgment in Animal Welfare Board, has found that the conduct of Jallikattu is violative of the provisions of the Central Act, particularly 3, 11 and 22. considering the vital role played by the event of Jallikattu in preserving and promoting tradition and culture among the people in large parts of the state of Tamil Nadu, and also considering the vital role of Jallikattu in ensuring survival and continuance of native breeds of bull, the government of Tamil Nadu has decided to exempt the conduct of Jallikattu from the provisions of the Central Act 59 of 60. Therefore, the government has decided to amend, etc., etc. So I would respectfully submit that when you apply the traditional test under Article 14 of having some sort of a reasonable classification, for example, that is not met, because here, frankly speaking, while the state might have an objective with regard to a particular type of bull, there's nothing on the ground to show that there is X or Y or Z. But those bulls must be preserved. I'm not saying that line must be preserved. But this is not a condition, precedent, or even a requirement for preserving that line of native breeds at all. There's no rational nexus at all, and certainly not if it is subjected to this kind of inhuman and cruel treatment. That's my respectful submission.
While you're on Article 14,
Yes.
you have also raised the argument based on Article 14.
Yes.
This 21, almost you have given up. Actually, you are not pressing that line of argument. 19 is obviously not available because the bull is not a citizen.
But 21, I told your lordships,
We have already said that. I mean, we have taken note.
and you recall, I read that report about people dying.
People dying. That argument is there. Actually,
Yeah,
it's
so-
not the animal as such being a.
No, and then I gave that penumbra argument, but your lordship is saying is absolutely right. I am not saying the bull has an Article 21 right, if that's the question being put to me.
No, we are putting something else.
Yeah, but there's an element of dignity.
You brought in manifest arbitrariness.
Yes, that's 14.
That's
And dignity,
that is
because
very-
dignity is an important asset, other council will develop it.
That's-
Dignity under 21 is an important facet of 21.
That's right.
And maintain, once we have a judgment of this court, apart from the non-retrogression argument, allowing something which is so cruel and torturous to a bull and compelling it to fight and contest lowers the dignity of each one of us. That's the submission, but that's someone else will develop. So I'm not putting sort of 21 into a waste paper basket for the purpose of my case, but it's not something which I'm going to elaborate on because others will do it.
I think please read Article 14.
Yes, of course.
Just read Article 14.
Yes. Yes. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Correct.
The question we are putting to you.
Yeah.
For the purpose of Article 14,
Yeah.
it doesn't matter whether you are a citizen or you are not a citizen,
Yeah.
but you have to be a human being. The word person. We're just putting it to you so that you can just clear because the same argument which you very rightfully,
Right.
in a manner of speaking, gave up the context of Article 21, personhood.
Right.
Whether the same problem will arise
Right.
in the context of Article 14 using the word person.
Right.
Can you say that?
No, so it doesn't arise. It doesn't arise. So let me answer that. We are on the text. Let's answer that straight away. The protection under 14, couched as it has, prevents or proscribes the state from violating equality in whatever manner. Obviously, the impact eventually will be on a person. But now let me answer respond. Supposing you have an arbitrary classification which doesn't deal with persons at all, but it says there's an arbitrary classification in a schedule to a taxing statute. There's an arbitrary classification with regard. So it has nothing to do with a person as such. You may only have companies, etc., which are impacted by that taxing statute.
It will always relate to a person.
Yes.
Yes.
It will not see that.
So everything will come back to a person.
Classification relating to inanimate things.
Yeah.
But it relates to the right of a natural or a legal person.
That's good.
We are just trying to put to you that I don't
Right.
Otherwise, you can't be having something in the abstract. It will always, rights are always related. They are always relative. There is no absolute right in the first place to begin with.
Right.
You
They are qualified.
your life.
Yeah, the subject to
Your life is not absolute.
Correct.
So when you are talking about right in the Article 14,
It must come back to a person, Milord Zena. I'm not saying for a moment that it doesn't come back to a person. So, sorry.
So there, how will you actually deal with it?
No, so I will deal with it in this manner. I will deal with it in the manner that as far as 14 is concerned, I'll just explain, at least as I understand it, the evolution of the law. Initially, your lordships interpreted 14 or as a basis of falling foul of a classification test. And this was a manner. Of course, fundamental rights are in a sense linked to individuals. They may be citizens, they may not be individual citizens, and as your lordship says, it may be a corporate person as well. No problem, difficulty with that. So, in the first realm, the construction and the manner in which this court interpreted it was on the basis of the classification test. Then your lordship supplied a further dimension to the issue, which was with regard to arbitrariness. So, arbitrariness also became a factor and even dehors the classification test if some action was found to be arbitrary. Then again, it was liable to be or potentially liable to be struck down. Now, that doctrine has further evolved and has further dimensions. Manifest arbitrariness is yet another factor or an aspect of it. And 14 has now been read with along with 21, 19, etc. and draws sustenance from all of them. So, my respectful submission is the manner in which 14 appears. Yes.
There is one more issue there
Yes.
when we flag it.
Yes, yes.
You see, how the law is developed from a mere classification. Of course, we had Anwar Ali.
Yes.
Right from Justice Vivian Bose, made that.
Yes.
But apart from that, the milestone is, of course, manifest, where you
Yes.
have a different approach to Article 14.
Yes.
So all of this is founded on a triangle approach. The
Yeah, I agree.
triangle is
Yes.
14, 19, and 21.
I believe that's correct.
Correct. Now, because the unenumerated rights in Article 21,
Yes.
rights which are proclaimed specifically in 19, you can find them, discover them, which has been done very effectively by this court in 21.
Right.
For all of that, you need the indispensable, the sheet anchor is, you need to have the premise 19 as well. Now, 19 obviously will not be available to an animal because he's not a natural person under the Citizenship Act. Only a natural person, as you know, the line of decision which says that a corporate body cannot, for example, maintain a 32 by itself. It has natural shareholders. So, unless and until you have 19 also being available, which is impossible in the case of animals because they can never be citizens of India. How do you bring in the theory of arbitrariness for animals? They're just dumb.
Yeah, so I'll just explain that to you.
We want this.
No, so let me just explain that to the court. Okay. So there has been, your lordships are correct in, identifying various markers in the development of our constitutional law. Now, there are two elements over here to it, which have worked simultaneously, particularly since the mid-80s.
Yeah.
One element has been the lowering of standing. And along with the lowering of standing or the lowering of the threshold for standing, locus standi, you had equally an expansion of rights under our Part 3 to extend and to cover rights which were, in a manner of speaking, not articulated expressly in the Constitution, but were found embedded because the value was there. And therefore, as the Constitution has been interpreted as an organic document, etc., moving forward, those have been ready. So now take the example I gave yesterday was the simple example of the right to a healthful environment or a wholesome environment. So that's not mentioned anywhere in our constitution, but it was derived right from the 1980s when you had, for example, the Dehradun quarrying case and a 32 petition was entertained, even though it was only in the early 1990s that for the first time it was said that the right to a healthful environment is actually embedded in the Constitution and in Article 21, and therefore we will engage the review. Now, what is the consequence of these two? What you have is situations. Now, for example, I'll just indicate, take something like the Wildlife Protection Act. That was also mentioned by Mr. Luthra. Now, in the Wildlife Protection Act, broadly, you have protected areas in its latest iteration. So you have, broadly, national parks and you have sanctuaries. And then you have other protected areas as well. Now, when you have a national park and a sanctuary, one way of looking at it is that, look, if there's a national park and supposing the boundary of a national park is arbitrarily altered, I'm giving you an example. Who are you as a human being to challenge it, etc., under 1419 as being arbitrary? Because ultimately it's a question of the animals, etc., and they are not coming forward and they have no rights under 14, etc. But because we have lowered standing, because we have expanded the right under Article 21 and Article 14, it is available to a citizen to come forward and challenge an aspect, say, of the Wildlife Protection Act with regard to the alteration of a state boundary or of a national park boundary. Equally, now I'm coming to another example. You have schedules to the Wildlife Act. So certain schedules, that is also referred to by Mr. Rutra. So certain animals which are in a schedule enjoy the highest degree of protection no matter where the animal is. So even if so whether the animal is in a sanctuary or outside the sanctuary, take a tiger for example, you can't kill a tiger except in terms of, so it could be well outside a protected area. Then there are species, all species are protected within a protected area. Certain species are protected whether within or outside the protected area. That's the broad scheme of the act. Then you have protections for plants, etc. also under that particular act. Now, if there is a violation or a movement, say, of a species which has enjoyed a higher degree of protection to a lower degree of protection, then the question is, what is to be done? So, is there any violation which has taken place? The answer is that through the human agency, this court has allowed. Now, for example, at 3 p.m. today, there's a special bench which is being constituted in Court 1. What is the thrust of that case? There is a bird called the Great Indian Bustard. It is on the brink of extinction. Now, the challenge in that particular petition under 21 is it's not that the bustard has come to the court over there and said that, look, my fundamental rights under 14 and 21. But there is a violation of rights because the state action has been found, or there's already an order of April 2021 of this court, finding that certain directions and rights have been infringed. The directions, certain action, I shouldn't say, certain action has been found to fail the rationality and reasonable test for a particular species. So the answer is not that that species fundamental right under 14 is violated. The answer is in the context of that species, action which is being taken is arbitrary. And that allows an individual under the lower threshold under Article 14 to approach the court. Of course, a person may be right, a person may be wrong. But the threshold point which your lordship is correctly putting to me, that look, if it is not, if 14 is meant only for a person and 21 is only meant for a individual human being, then what happens insofar as bulls are concerned? So through a human agency, whether it is an animal protection agency or whether it's a statutory board like an animal welfare board or whatever, so what's our case just go back to the Nagaraja case. That's key before we had this act. What were the broad thrust of the case at that time, the earlier round? The broad thrust of the case was that, look, you have, apart from, I'm keeping aside this business about legislative competence, keep that aside for a moment. The point was that, look, you have a statutory board called the Animal Welfare Board, etc. This and the state, which is under a constitutional duty to protect bulls, is failing to do so. And the court, alive to this consideration and constitutional duty and responsibility, enforced it through its judgment. Now the judgment is available to us. So this is broadly how I would respond to 14. And I would respectfully submit that I don't think, I mean, of course, there's no second guessing what the state of Tamil Nadu will argue or any of the other states. But my sense is that the law has developed now by which an individual or a group or a registered society acting bona fide can approach this court and point to certain actions which are arbitrary, etc. So arbitrariness comes in another manner as well. It is a facet. It's a, when you have, if we are right, or even if if we may not eventually be right, but if there is some case for consideration, let me put it no higher than that, where a state seeks to overrule a Supreme Court judgment and breach the doctrine of separation of powers, which is fundamental to our constitutional scheme, I believe a group can bona fide come before the court. Your lordship will put each group to the test and say that, look, are you really bona fide or not? That's a separate answer and a threshold.
Yes.
I understand, I didn't know this, but I understand that Mr. Nagaraj had lost his son in that earlier round. He had lost his son in Jallikattu and therefore was seeking relief, etc. And including direction. That's the genesis of that earlier matter.
Awesome.
So, yeah, so there are dimensions of that. That is, of course, a direct impact situation for the foundation of the case. But this is broadly where we stand on our understanding. Now, since we are on 14, let me just tie up this submission by referring to one 7-judge bench judgment. I'll just give you the citation and I'll give you the paragraph. It is Nagpur Improvement Trust versus Vittal Rao, 73-1 SEC, page 500. And the relevant paragraph is para 26 at page 506. Now, let me just, while the book is being located, there's just one para that I want to read. While the book is being...
Most quoted judgment, actually.
Oh, I see. 73-1.
Number of
Your Lordship will recall the facts. The facts were there were two methods of acquisition of land. One under the Improvement Trust Act, one under some general acquisition law, etc. But it was resulting in different sets of and different amounts being available to the party. In that context, 14 was examined and looked at very carefully. Is the book there?
Prior to this,
so,
Manil Gandhi.
Yes, 73. Yes, it is prior. It is prior. So, Beloveds, I'll just indicate what the paragraph said, and
it's a part of the classification test.
Yes, so but it's got one dimension. First of all, Your Lordship is absolutely right, correct in your recollection. It's pat on. It articulates the test. Now, the element which I am relying upon is not just that the classification should be clear and precise. That's one element. Second element is that it must have a rational nexus to the object being received to be received. But there is one threshold requirement even prior to this. Even if your classification is clear, even if it has a rational nexus to the object sought to be achieved, there's one element which is at times forgotten, which this 7-judge bench articulates and is followed in a subsequent Supreme Court judgment, several, as Your Lordship said, but a constitution bench in Subramaniam Swamy as well. And that is that the object itself must be lawful and this is very, very important for my purposes. So the question being put to me is, or was put to me a little while earlier was, that look, you want to protect species of local bulls, etc. Is that an unlawful object? Certainly not. It's the most lawful object. But the issue is the means and the ends. You want to protect your a certain indigenous species, etc. By all means do so. But the manner of doing so, the object in that sense may be good. But to allow Jallikattu to do so is impermissible in law. That's an impermissible object. It's not a lawful object according to us. Yes, I'm sorry.
See, that observation was made in the context of the twin test.
Yeah.
In the context of the classification theory.
Absolutely right. It is purely that.
That object should be lawful thing.
Yes.
Itself is a part of the classification theory.
Well, first of all, I agree with that. Absolutely. So the argument therefore is...
So here there is no problem about classification. We are not on classification at all.
No, we are on classification.
No. Here nobody has raised the argument of classification.
Of course there is. It's a square on.
Please tell us.
How classification. Yeah, all right. So I just articulated in the most basic sense.
Yeah.
Bulls form a single homogeneous class. As far as bulls are concerned, as a classification. Now, if you are creating a certain subclass to subject certain types of bulls alone to cruel, unusual, torturous treatment, that is impermissible in law. So that's the traditional classification test, one element of it.
You never argue, that's why we're telling.
Oh, I see. I thought Mr. Luthra said, he said it. But anyway, now it's just a one single sentence point. So that's the point. So that's the first traditional point. Now I come to the second element. So I am trying to argue with this on the traditional test under 14 and on the more expanded test. So now I'm completing the second sentence is also on the traditional test. So therefore, my point is that you ought to, I can't say must, but the legislature ought to be alive to the interests of all the bulls of that species. You cannot create an artificial distinction over here and certain bulls who are subject to torture, etc. If your object is to allow the entire species, etc. to flourish, by all means do so. So this is an impermissible classification of bulls which are put in the ring and which are subjected to unusual treatment. So this is one part. Second,
where is your pleading in this regard? Have you made
the 14 ground?
No. Have you raised the pleading?
I hope it's there. I mean,
yes. We also hope it is there.
14 point, my lord. It's a
no. This point is interesting. So that we'd like whether you're serious about it.
I have certainly. I mean, I must confess, I've not seen it in my pleading, but I've not seen my pleadings at all. I've seen the reference questions which your lordship put to the court,
right.
And that articulates 14.
Correct.
as one of the questions which has come up before this larger panel.
14 in the context of manifest arbitrariness is different from classification. So there we are asking you whether there is any pleading which you are now seeking to sort of argue.
I think there is at best it'll be some general pleading, but I'll try and locate it. Now, in any case, so the point here is 14 is very much there. 14 has various dimensions. Once the other side is on notice that there is a 14 issue, it has to cover, it has to be prepared and ready to answer all dimensions of 14. 14 is an evolving issue and 14 is in the reference order. So anyway, I will try and locate it from the pleadings, but I'll just tell your lordships. So this is one element. Now there's a second element to 14 in terms of the classic. So one is, so all bulls form a single, I mentioned that element. Now we come to the second. The object itself must be something, in the context of classification, Lord, in the object, what paragraph 26 says is that in this connection, it must be borne in mind that the object itself should be lawful. The object itself cannot be discriminatory. For otherwise, for instance, if the object is to discriminate against one section of the minority, discrimination cannot be justified on the ground that there is a reasonable classification. It's the same thing. So now, so that I have made that point. The object is bad. Why? Because you cannot subject certain elements, certain animals to cruelty. I mean, because we have a judgment in our favor on that, and I don't believe that can be really overturned. So that's the second element of it. The third element why the object is bad, again, traditional classification test, is because it is completely in breach of the doctrine of separation of powers. So yes, you may strike it down as colorable under separation of powers, but dimensions of 14 also kick in over here. Why? Because your whole purpose, your statement of objects and reasons mentions a judgment of the Supreme Court. And thereafter you say that I want to decide on the facts in the case. I want to decide on culture, etc., which is already decided by the Supreme Court. How is that permissible is the question I ask myself. So anyway, that is in itself, in our respectful submission, in the most traditional form of violation of 14. So now, Manoj, I'm done with 14.
The legislature not say that this is culture.
Yes, so now let me answer that. Let me answer that straight away. And I am in this regard fortified by the judgment of the Constitution Bench judgment of this court. So just allow me to go back to one paragraph in the judgment of Kerala versus Tamil Nadu, which I had cited yesterday. But let me answer the question. Let me answer the question. The answer to the question as we understand it is...
No, we remember that paragraph.
Yes.
Where you said that the purpose of a legislation cannot be to take away a vested.
No, not that. So first of all, let me try and furnish an explanation if we are right. I'm only answering the question. The legislature, which is plenary, may in many situations, virtually all situations or almost all situations, have, say, a deeming fiction. All right. So let's start with that. So can make a man, a woman. I don't know whether gender analogy is really very relevant at this time. But
tomorrow says morning is to be called.
Yes. So you can have a legislature which says morning is evening, sun rises on this side, etc. No problem with that. You can have a deeming fiction. That's the general traditional notion of plenary power of a legislature, so long as it has subject matter competence. But then, with the progression, we have situations where the court decides. This is the most crucial factor. Once the court decides, this court or any other court, but certainly as far as this court is concerned, and it decides on an element of fact, not just based on fact, but it decides something on facts, and it decides an aspect of the law, namely, in this case, to answer the question as to whether there was a cultural root to a particular, and rejects it, then the legislature cannot overturn the judgment of this court through a legislative process, because that violates separation of powers. So to answer the question, could they have done this before? Could they have done it? They did it through the 2009 Act. And I concede that instead of doing it through the 2009 Act, they could have amended the prevention of... For my purposes, I've conceded that because I've said it falls under 17 of the concurrent list. For my arguments, someone else may have another submission. So I'm conceding that position that they could have done this in the first instance. The point I'm making is they cannot do it after the Supreme Court judgment, because that's what violates separation of powers, and that is why this court held that after this court in Kerala versus Tamil Nadu has said that, look, 142 feet is the dam is safe up to 142 feet. The Kerala legislature cannot, on an appraisal of facts, come and say that, look, I am deeming it that it is safe only up to 132 feet. And after that, the board is to decide. You can't undo a judgment of the court. That's the point. Once there's a factual determination, the whole arena shifts and moves into another space. And the matrix for evaluating the correctness of a judgment would be different before or after, even though you may have had a deeming power before that. So, Millards, now I'm done with this particular thing. Your Lordship has already read that portion which says, cruel, barbaric, and inhuman and savage. Now, once a judgment of this court holds that certain conduct of Jallikattu is cruel, barbaric, inhuman, and savage, I would respectfully submit that any object to advance that kind of a practice is per se illegal once this court has so held. So anyway, I'm done with that submission. Now, my lords, there's one article on the sentient, and then I'm just going to go to those other 2-3 points which remain. So on the element as far as sentient creatures is concerned, there's just one article that I want to read, and that is just to explain, because this is a recent article in 2018 or 19. Have it given it? Please give it. So I should just mention, there are 3 pieces, 3 scholarly works which are already there in the convenience compilation. I am referring to the most recent one, which is in this new volume which I am handing over, and I am going to read only 2 or 3 paragraphs of this. So just so that you have an, just very quickly, just 2 paragraphs from this. So please go to page 8.
Yeah.
Now this is a piece by Suresh Kumar Sanjay Chowdhury et al. And it has been published, your lordships may just note, in the Animal Sentient, the title your lordship knows, it's in the International Journal of Current Microbiology and Applied Sciences, published in August 2019. You'll find that number and the reference right at the very top. Now, what is this new understanding? Let me just see. See the first paragraph. Sentience is the ability to perceive and feel things. An animal is sentient if it is capable of being aware of its surroundings, its relationship with other animals and humans, and of sensations in its own body, including pain, hunger, heat, or cold. In 2012, an international group of eminent neuroscientists signed the Cambridge Declaration on Consciousness, which confirmed that many animals, including all mammals and birds, possess the neurological substrates that generate consciousness. It is logical to suppose that sentient animals also enjoy feelings of comfort, enjoyment, contentment, and perhaps even great delight and joy. A sentient animal is a being who has interests, that is, a being who prefers desires or wants. These animals naturally try to avoid suffering and seek positive experiences. Just like humans, animals have evolved to cope as successfully as possible with life in the wild, thousands of years of domestication of farm animals, etc. So this is just to give you an introduction as to what is sentient and what is the direction in which the science is moving. And then your lordships may look at it if your lordship consider it appropriate. I think it's a very nice article. Brings us up to date. Please go directly to page 16, just in the conclusion. You will find in the right-hand column, sentience and cognition. The attribution of sentience to animals can also be hindered by the common misconception that capacity for sentience is linked in some way to the species' cognitive ability. Cognition refers to the mental action or process by which animals perceive, processes, and store information. Sentience, on the other hand, refers to the capacity of an animal to have feelings and to be aware of a variety of states and sensations, such as pleasure and suffering. It is often assumed that cognition and sentience are inextricably linked, in that cognition automatically implies sentience. Indeed, evidence of higher cognitive abilities, such as theory of mind and language, has previously been used as a basis for advocating for the rights of certain species, such as the great apes. Cognition is not actually a prerequisite for sentience, and it can be demonstrated independently. Developing our understanding of animal sentience is imperative for improving animal welfare and attitudes towards animals. Concentrating on filling the gaps in our knowledge humanely and reliably is essential given the extent of human impact on animals, with increasing attention on animal sentience, science and the further development of human approaches, the future of the science of animal sentience is looking even more promising, and as a result, so does the treatment of animals. So I am trying to only urge to the court that on part of that non-retrogression argument, that the science is actually moving in the direction and pointing in the direction which our court pointed us to in 2014. So this is the short point that I wanted to make with regard to sentience. Now, 2 or 3 points remain. One is in answer to your lordship's question yesterday with regard to those rules, and Justice Rastogi raised it this morning. So let me just hand over what has happened as we see protective measures and guidelines, and then go on here, read it. Give it to the other side. Now, very briefly, those reports which we gave, as I mentioned, and which we placed year upon year, have not been meaningfully contradicted.
Yeah.
Now, just let us see how this works. This table, your lordship has the tabulated statement.
This is the most important part, actually.
Very well. So, all right. So,
No, because this is what.
no, this is weighed with the court. So we put in, I mean, some effort. Let us hope it is adequate. Now, let me just summarize what broadly where we come out from. In one line, it's all old wine in a new bottle. That's one general comment which I want to make.
Yes.
The second comment I want to make is that, look, while there may be a particularization under the 2017 Act rules, because the 2017 Act I placed in the morning, there's nothing really in that, it just carves out an exception. While there may be a further particularization, broadly what you will find is that the particularization, according to us, was already captured by some general catch-all phrase or responsibility or duty earlier. So please keep that in mind. That's number 2. And the third thing is that certain features which were present in 2009 are in fact diluted insofar as 2017. The other 3 broad points. So let's just see how this works. So now see the Tamil Nadu regulations, regulation of Jallikattu Act 2009. I'm on the first page. So regulation of Jallikattu. So the first is no permission under subsection 1 shall be granted to any person to conduct the event unless the collector satisfies himself that the event is conducted in January to May. The place selected is suitable for orderly conduct. The event should have been conducted during the past 5 years continuously. The event shall be held in a place notified by the collector in the district. Then we have set out, my lord, section 3.2 for your reference. Now look at the responsibility which was imposed on the organizer. Every person who organizes the event shall take all precautionary steps for the orderly conduct. Inform in writing if the collector, to the collector 30 days prior to the date of the event and obtain his permission. Double barricade the arena way through which the bulls pass, though in order to avoid injuries to spectators. Fix up the gallery for the spectators to sit and watch the event. 5. Arrange to obtain prior permission of the collector to persons who wish to bring their bulls to participate in the event. 6. Ensure that the bulls are put through proper testing by the authorities of the Animal Husbandry Department to ensure that the performance enhancement drugs are not administered to the bulls in any form and shall obtain a certificate to that effect. 7. To arrange and enroll the names and other particulars of the bull tamers in the event, with the collector at least 15 days prior to the holding of the event, and the bull tamers shall also be put to a thorough checkup by a medical team. Ensure that every bull tamer wears an exclusive dress for the sake of identification. Deposit with the collector a sum to be determined by the collector, which shall not be less than rupees 2 lakhs, etc. And then we have mentioned over here, overleaf on page 4, this has been omitted under the asterisk portion. Those responsibilities we have said have been omitted in so far as 2017 is concerned. Now, just moving on, carry out the responsibilities that may be prescribed. Then the arrangements made to be made by the collector, a very important section 5 of the 2009 Act. Collector shall ensure, so organizer's responsibility, now collector responsibility, ensure double barricading, ensure that the number of spectators does not exceed the limit under the prescribed by the PWD, ensure safety certificate by PWD, ensure that the bulls are free of any diseases and not intoxicated or administered with any substance like nicotine, cocaine, etc. Arrange and provide adequate police protection at places where the event is held. Arrange to provide adequate medical facilities, including the ambulance at the places where the event is held. 7. Arrange the necessary drinking water supply as well as sanitation facilities in place where the event is to be held. 8. Authorize the officer not below a rank of deputy collector to look after each item of the event arrangement, like checking up of the bulls, checking up of the bull tamers, checking up of barricading, gallery arrangements, medical facilities, water supply, sanitary arrangement, and safety of the spectators. Arrange to give wide publicity to the provisions of the Prevention of Cruelty to Animals Act 1960 and the rules framed thereunder, and the risk involved in participating. Ensure the presence of animal welfare activists representing the animal welfare board. This has been completely removed in 2017. Videograph the entire event and provide the same to the government or any other authority as required, and make such arrangements as may be prescribed. Now I'm pausing here for a moment. This is a reading of Section 3, Section 4 of the 2009 Act and Section 5. Now I first make my comment and then I go on to the right hand side. After this, had the court's approach been, which I don't believe may have been a correct approach, subject to, of course, what your lordship say. If the court had said, Nagaraj, that look, these are rules, these are sections, these are statutory provisions, everything is fine, everything is perfectly conceived, etc. There is really no occasion. If there is someone remiss, if there is some deviation, then the recourse is for the party to be prosecuted or penalized or take action, etc. Answer is no, that may not be the correct approach. The correct approach for the court was what it did. It examined reports and affidavits, detailed reports and affidavits, where each of these obligations, your lordships have seen it, I don't want to take you, as far as the safety and sanitary conditions are concerned, as far as the violence and the pain is concerned, as far as the alcohol and other elements are concerned. I'm talking about Nagaraj. I'm not talking about my report. I'm talking about the reports and the affidavits which came before this court, which are extracted in extenso. And the court found that despite these so-called safeguards, the whole thing is illusory. And therefore, given the cruelty being heaped on the animals and the injuries, etc., which are being suffered, and the cruel and inhuman treatment, it doesn't comport with our sense of dignity. It doesn't comport with the requirements of the Act, the Prevention of Cruelty to the Act, and the purpose of the Act. Now see what they have done in 2017. I'm going to read this all on the right-hand column, again serial number 1. I'll read them in full. The Act itself is just the carve-out. So now they have the rules. Set out the procedure for conduct of Jallikattu. Rule 3.1. Any individual or organization intending to conduct Jallikattu in a place so-and-so under Section 2DD shall inform the collector of the district. Same thing is there. Organizers shall also obtain prior permission from the collector. Same thing is there. The collector shall grant permission for any Jallikattu, cause an inspection of the venue. Exactly the same as was there earlier. 3.4. Provide for formation of a committee of Jallikattu, which includes revenue, animal husbandry, police, health department. Your lordship recalls the earlier provision was to the same effect. Namely, these people had to be involved. Rule 3.5 specifies that the organizers have to ensure that the bulls are tested properly by the animal husbandry department. There was a mirror provision earlier. Provides for the collector shall ensure that help of animal husbandry department.
Don't rush there.
Sorry.
3.5 is important because
yeah.
It says, and no performance enhancing drugs,
Yes.
irritants,
Yes.
etc. are administered to the
Yes.
correct.
Yes.
Now this word irritants, etc.
Yes.
Because when you're challenging a law,
Yeah.
it's always open to the court to actually read it down, to make it constitutional, as you are aware.
No, so see the earlier provision.
Because earlier provision did not provide for etc. irritants, etc. So
But I'll just read the earlier provision. The collector had to ensure that the bulls are free of any diseases, not intoxicated or administered with any substance like nicotine, cocaine, with the object of making them more aggressive or ferocious.
There were performance enhancing narcotic substance.
Yes.
That apart, what we were really concerned, and we're going to put it to Tamil Nadu also,
Yeah.
whether they have, prevented, like spiking, like poking it with.
Of course, that's prevented, Manoj.
That is whether that is there or not in the rules.
But they're definitely there. The Tamil Nadu government is not allowing any such treatment. That can't be done. But it is being done. The problem, just imagine, as your lordship sees, if in your time your lordship goes through the photographs, you will see that those prods and those things are being used, and the whips and the lacerations, etc. are there, and those are documented in the text.
Were CCTV cameras, was it there under the old?
Yes, it was. Videography was there. So, brothers, as technology evolves, now you will have a live streaming also. We are not on that. But earlier, videography was there. I read it. Please just see the earlier rule. Where, sorry, page?
Videography may not be the same.
Page 5.
Videography
No,
may
page
not be
6.
the same.
Page 6, 9.
Page 6.
Right.
CCTV camera
Prominent
monitor
model.
all activities.
Videograph the entire event.
Yeah, videograph. You're absolutely right. 11. I think it's 11.
CCTV
Aye.
camera, Shyam,
Yeah.
CCTV camera to be fixed to record and monitor all activities is different from videography. Because videography, if you are going to capture only the parts, which are really palatable to their site, you may not get the whole picture.
Well, I
You're
think
saying CCTV camera, as long as it is working, if you not allow it to work, is it?
your lordships have experience of CCTV camera. Can I share something?
Yeah.
Yeah. The CCTV camera is, I mean, apart from being an obnoxious invasion of privacy, because you see it all over the city just now. I mean, not just public streets. We now have a mandate in this city that you have CCTV cameras in schools. I mean, one thing which I thought we were left with was at least childhood, where you can, we now have CCTV cameras in classrooms, etc. But anyway, that's for another day. Now, the point I'm making is that the CCTV camera enables you to reconstruct in certain situations. The granular condition of the feed which you get may or may not, because a lot of it depends on the angle from which the CCTV camera and the event which takes place. So, I mean, since your lordships have allowed me to share a personal experience, I can tell your lordship that I know of a particular person, a close relation, who had CCTV cameras which were installed for security purposes. The persons who are engaged in mischief just shifted the CCTV camera in another direction, etc., and did exactly what they pleased, and thereafter refitted the CCTV camera or whatever in the manner. So CCTV camera, while it may serve a certain purpose. I'm not saying it doesn't serve a purpose, but essentially the benefit is not going to be with respect to those particular bulls for whom we have come over here and to prevent cruelty. It may, in some instances, prevent some reconstruction of events and to say that, oh, I said this and you said that. But you are not going to be able to really, in my experience, enhance your law enforcement. So the purpose of now I'm coming to this. The purpose of the CCTV camera across the world, by and large, is, and your lordship actually said it, that the CCTV camera should work. CCTV cameras are stationed in many parts of the world only to ensure that the action which a person takes is somehow, it's to prevent improper action. Actually, those cameras are there. There may not even be a camera inside. There may be no feed. But the idea is it's a tool of deterrence. Because there's a CCTV camera, and X or Y or Z may feel that, oh, I shouldn't do X or Y or Z. But in reconstruction of crimes, etc., it may be possible. It's, of course, at a cost. But what I am trying to suggest to the court is that by having some, some small little improvement here and some, embroidery over there.
The basic rule.
The basic rules were there in 2009. Despite the basic rules in 2009, you had widespread violations which have been now found to be established. And therefore, my urging is twofold. The first urging is that perhaps, possibly, a wiser way, or maybe I'll withdraw that expression wiser, but a better way of examining this law, the present impugned law, is the effect of the law and not based on the theory. Why? Because we had a submission, we had elaborate rules earlier, statutory provisions in a section earlier, but those failed to pass muster. They did not result in any meaningful alteration in conduct of the event which would be beneficial. So am I suggesting that every Jallikattu event? No, I am going by the basis of the record. The Supreme Court will have the 2014 Nagaraja judgment. I just gave you from one or two of those particular districts. It would be wrong to take up your lordship's time and read each one of them. At so many of the districts, the court found brazen violation year after year. Now, if you have this kind of treatment with statutory provision, this was, don't forget, this was sections in the Act. This was not even subordinate legislation at that time. Today, it is subordinate legislation. Not that it's subordinate legislation should be flouted. I'm not suggesting that. But it was a higher order, the 2009 State Act, which was completely breached wholesale. So, to complete, at least for this first set of obligations on the collector and on the owner, pari material, you may not find it court by court, but essentially the person has dressed it up and put it in the form of rules where all those say, because I'll tell you why. The reason I'm making is, I don't think the intention of the state as such, it was obviously the 2009 Act, the idea of the state was, it was hopeful of having some regulatory exercise. I'm not suggesting that they were some, the state government, they were not acting, they were acting bona fide, but even when they were acting bona fide in 2009, the legislature, on the ground, it didn't yield anything at all, as this court has found. And putting this old wine in a new bottle and trying to market it ought not to pass muster. So this is the first point. Now let's go to the second set of, please go to page 6. Now look at section 4 earlier. Ensure that the bulls are put to proper testing by the authorities of the Animal Husbandry Department to ensure that the performance enhancement drugs are not administered to the bulls in any form and shall obtain a certificate to the effect in such form as may be prescribed. Ensure that the bulls are free of any disease, not intoxicated, etc. So this was 4, 6 and 5, 6 of the section. Your Lordship has page 6, serial number 2. Now the Your Lordships have page 6. So the left-hand column is 2009, correct? Now look at the rule 4 at page 6. Look at rule 4 on page 6. Examination of bulls. The bulls shall be compulsorily subject to veterinary examination by qualified veterinarians of the Animal Husbandry Department. Now, obviously, Manoj, when the earlier act also envisaged, the word veterinarian may not be used, but obviously the Animal Husbandry Department personnel would be all vets. Otherwise, where's the question? A general lay person in the secretarial staff has no competence to say whether there is nicotine, cocaine.
Quantitative difference from the earlier section 4 with what you have put on the right-hand side.
Right.
The earlier thing was to see that are not administered any performance enhancement drugs, not administered, number 1. To ensure free from any disease. And
these are not a quotation. You should just know. I've asked them to paraphrase it. Just telling you, it's not a quotation.
That's right.
It's a paraphrase.
But if you contrast it with what you find on the right-hand side, they include both showing symptoms of fatty, dehydration, restlessness.
Correct.
Shall be identified and not permitted.
Yes.
These bulls shall be examined specifically for possible alcohol and any subject to any such abuse shall not be allowed to participate.
Right.
So it is more elaborate.
I agree with you. I am for a moment.
More elaborate and goes to detail.
So may I just answer that? May I just respond to that? First and foremost, it is not necessarily more elaborate in the sense that it was not covered earlier. So I'll just explain that. You might have had a particularization in the 2017 rules, which was not particularized in the 2009 Act, but it was covered by the 2009. Well, let's
the matter goes to substance.
No, I'll just explain.
Particularization itself is such that it knocks out the basis of the cruelty according to it. That, for example, if you see a particular bull, see, there are bulls and bulls. They may be trained, they may be fed.
Right.
Correct. But at the time when the actual fight takes place or the Jallikattu takes place, the officer whom we have to pursue by statute ordains that he should perform a particular act. So he performs his act. Let us assume that the act actually goes on well. That's one way of testing the constitutional law.
I agree, but that is, if I were arguing in 2013.
The bull showing dehydration, restlessness, identified, not permitted to participate.
Right.
So this was not there earlier. They were not.
No, it was very much there earlier.
No.
And I'll show you the corresponding provision.
Not there.
No, I'll just show you that. Just give me the equivalent to that. We'll give you the equivalent provision as well. So, Manoj, I want to just respond to that situation. You had rules in the form, rules in the sense, I'm using the expression in the form of detailed statutory provisions in the section under the 2009 Act, which corresponded to this. You're quite right. The word vet may not be used, the word animal husbandry department may be used. But specifying a vet doesn't mean who else in the animal husbandry department would know X or Y or Z. There may be some further with the advance of science, for example, you may have a substitute of videography with a CCTV camera because CCTV cameras may be cheaper, etc. But that in itself is not a qualitative difference from the perspective of the bull.
Rule 5 you come to. That is very important. Rule 5 over the page, yeah.
Just give me a moment, please. Sorry.
Rule 5, if you in the meantime, if you may read.
Yeah, Millers of the new rules?
Yes.
Yes.
Over the page, next page, page 7.
Yes, so may I just read that?
There is no equivalent in the earlier.
Yeah, that is so. Arena shall be at least 50 square meters area. The bulls have to be embraced by the participants within 50 square meter area. The participants shall not be permitted to stand in front of the bulls as they enter. They shall also not be permitted to block the exit way for the bulls. The participants shall be permitted, etc., some 15 meters or up to 30 seconds or sustain 3 jumps of the bull. The participants shall not hold on to the tail horns using their hands or restrict the movement of the bulls by holding on to the bull's legs. The participants violating these guidelines shall be liable to be debarred.
Just pause there for a moment.
Right.
It's a matter of some moment because
Right.
you're talking about the flight response, the fear.
Right.
A large part of this fear can be attributed to the acts of the human being, holding on to the tail. Now, this is that part. We thought that there might be of some importance.
So I'll just tell you. Let me just tell
Talking
you.
out the basis of.
So let me just the foundation of the previous judgment. Let me just explain that to you without reading any paragraphs. The idea, I'll just explain it to you in a very general sense. So you have a bull. The bull is a domesticated animal. It is being, revered for the rest of the year, etc., and it does what a bull does. Now, at this stage, now it's a calm animal. We don't know what's passing through its mind, but it's sentient. That's what the science seems to suggest. It has a certain abilities over there in terms of pain, etc. Now, when it is put in an artificial setting, this is now the performance ring, correct? You remember that the performance was banned for all the circuses. That's why today our circuses don't have it, including insofar as bulls are concerned. Now we are coming to that, whether it's a bullock cart race or this. I am concerned, of course, with Tamil Nadu. Now, what's happening in this context is that suddenly the bull, from doing what it generally does, which is whatever, munching, eating, browsing, etc., it is put into an arena. Now, putting it in an arena itself may cause or trigger a certain panic by which it wants to leave the arena, but it is not able to do so. It wants to flee. The flight or fight response is that generally the bull will fly. It will try and leave, but it is completely barricaded and prevented. That itself is cruel. That itself is cruel insofar as an arena with spectators shouting, hooting, whatever, etc. So there's a panic response. Now I'll just complete, sorry.
Just when you say that.
Yes.
The second sentence of Rule 5.2.
Yeah.
They shall also not be permitted to block the exit way of the bull.
Yes.
Earlier what would happen perhaps is they would surround it.
Yes, there is.
Create that flight response. So the human beings derive joy out of it. That is an animal right in front of us.
Of course.
That was the whole idea.
No, but
they have now made a change. The radical as it appears to be that they shall not stand in the way. They shall not stand in the beginning, that is in the entry point. They shall not block the exit. So they have made it a little bit, at least.
No, it's like participants, my lords.
I'm talking about the participants.
But who is to tell the bull? The bull, I'm just asking your lordships. The cruelty is because you have a large arena. I'm assuming there's a large arena. You saw some of the reports that there was no arena and it was being conducted in the village center, etc. Keep that aside. Assuming you have a large arena, it's not as if the bull can read an exit sign or something like that and say that this is the way out and I will follow that and someone is blocked. There is a huge, my lord, spectacle going on over there. We have shown you. Now you may have to go to the photographs and see how it's actually conducted. This is not a parade or something which you see while beating the retreat with the horses in a leisurely manner coming. This is a spectacle. This is an event. And it's an event intrinsically. Maybe you may want to condone it. That's another matter. But intrinsically cruel as far as it has been played out in the recent past. Because I don't know. We don't know what the tradition. But at least from 2014, 2009 to 2014, we have a final judgment of this court. 2017 onwards, we have a whole bunch of reports of this court. It is still played out in a cruel and what we term as an inhuman manner. Because of, as your lordship said, there's some sort of a contest. There is some, people are trying to show their whatever notion of strength, etc. Because the bull itself is a notion of strength. But we believe that this is really, from any reasonable perspective, having a gate, which, I mean, I don't think anyone is suggesting that the bull knows exactly where the exit is, etc. It's not really, it's cosmetic. Let me put it this way. These changes are, in my respectful submission, cosmetic, given the overall, and given our experience. Why am I going into that? My submission is anchored on facts and on the basis of PETA reports. Anchored on the basis of those PETA reports, this is something which does not happen and the cruelty subsists. Now look at the next thing, point 4, the bull run area. Look at that. So earlier it was double barricade the arena or the way through which the bulls pass through in order to avoid injuries to the spectators. Sorry.
So we will, they'll have to do the explaining. You can perhaps, reserve your, if you wish to file a reply. I mean, make a
Yeah, correct. So your lordships have gone through the rest.
Yes, we have seen.
All right, I'm very grateful. Thank you. So now, my lords, and we have mentioned some parts which are not there. Rest of the table. Fair enough? Okay. So essentially, I mean, in a line, this is a cosmetic change. Right? That's my urging. So
we
just give me a moment.
have given you sufficient time.
Yes, absolutely.
More than.
Reported judgment.
In this case,
That's right.
as we will
So
demonstrate.
I'll just mention.
So, can we move on?
Yes.
Yeah.
Well, I'm done. There's just sorry.
Cannot hold on.
I am done now. I'll just take 2 minutes. I want to answer those questions which were also put to me, and see, just let's look. I mean, I'm just stepping back from what has happened. The broad submission that I want to make in terms of the legislature's ability, and I'm going back to the point regarding colorable. Once this court has found that this is inherently cruel, can the state legislature, through an amendment to the Central Act, modify the mandate under the Central Act?
These are suspended submission.
In my respectful submission, I'm just looking at it differently. If the state legislature could do that, what's the effect is the question I ask you. What's the effect? The effect is that a final judgment of this court, which can be only overturned by this court, without removing the substratum in terms of the factual determinations, etc., gets ultimately overturned. And that, I don't believe, is a permissible exercise, and therefore it is deeply colorable. Now, finally, Lords, the answer, can they not make a fresh legislation with safeguards? I have two answers. The safeguards were already there and they were breached earlier. The safeguards introduced since 2017 continue to be breached, and therefore, in our respectful submission, there is absolutely no justification for sustaining this legislation. I'm very grateful. Thank you.
Thank you. Thank you. Who will give you argument?
Tell us one thing. You argued from 2 o'clock to evening. 4 o'clock yesterday.
Yes, I'm sorry. I thought I'll take half an hour.
Without taking a drop of water even. Not water at all, and you're going on continuously. Without even.
This species is not a sentient creature.
With no cognitive ability. I'm very grateful.
After such a long time, that you just either have some sip of water.
I think I should have been briefer. But thank you very much. It was a very nice.
At least you enlighten us on a different subject. Totally in a different way.
Very grateful. Thank you.
Youth power.
Yes, Giri.
Wait, please, Your Lord.
Yes, you are appearing for.
So they beg to appear in the list of cases, my Lord, where different counsel are appearing. There are two writ petitions, my Lord, where I appear
For the petitioner?
for the petition. So I beg to appear in writ petition number 25 of 2016.
25 of
2016. And then writ petition number 1193 of 2017.
25 of 2016.
16. Yes.
The act came only in
It
2017.
was amended.
You have subsequently amended it.
Yes. Then, my Lord, there is anyway
1193 of
2017. That, my Lord, squarely challenges this.
70. Okay.
Yes.
So both are in Tamil Nadu. You are in Tamil Nadu.
Yes, yes. I'm only in that. I'm only in the Jallikattu.
So, see, the arguments have been fairly elaborately addressed by Divan.
My Lord, I will not-
tell you that, just need not repeat
No, no.
whatever is there. You can adopt the.
If your Lordships feel that I'm repeating
No, no,
anything,
no, no.
Lordships may
No,
want,
no, no.
I'll immediately stop.
Correct. Need to go to Karnataka and also Maharashtra.
Lord, I am aware of it.
We just want to tell you that.
I'll not
if it's possible. So that.
But it's only 15 minutes to lunch. I'll probably take half an hour to 45 minutes, not really.
Let us see, any new argument is there? Or?
Lordships may see whether there is anything.
Yes.
If there is nothing new, Lordships may cut me short.
We don't want to cut you short. We want to give you full liberty. Is it not possible that in return, after the reply comes forward, you get clarity?
Lords, let me do it now because a reply might be necessary once they do. They may have to reply to something which I argue now. They may have to. I believe they have to.
All right, go ahead.
Court master.
Well, Lord, just the basics of the contours of what I, my Lord, wish to submit with respect. The correctness of Nagaraja or the order passed, my Lord, in the review petition is really not one of the issues that come up for consideration.
Why files are not?
Correctness of the fine, sorry.
Files क्यों नहीं दे रहे हो?
5-0.
WPC 25 of 2016 and WPC 1190 of 2017.
I think it has been. All right, then Lordships may kindly confine to 1193 of 2017. That is enough. I thought it was amended the earlier one, but your Lordships may confine to 1193 of 2017. That contains a frontal challenge to this. The earlier 2016, your Lordships are right. Lordships may ignore that.
So 1193.
I had also prepared on the basis
Not
of
this,
the
not this.
2017 petition.
Court master, not this.
If your Lordships have. Only the 2017 need to be.
1193. 1193.
1193 is enough. I'm sorry to hear trouble.
Yes.
My Lord has to still get the files in.
No, we have not got.
After the. Right. Yeah.
My lords have got the fines.
Whether Roy is got it.
I've got it.
50.
Yes.
Yeah, tell us what your
My
point.
lords, please note 3 or 4 dates, my lord, which might turn out to be, my lord, relevant in developing my speech. Nagaraj, my lord, the judgment is delivered on 7/5/2014.
Okay.
7/5/14.
2014. Nagaraj, my lord, dealt with the competence and virus, my lord, of the 2009 Tamil Nadu State Act. Essentially. And it also went into the other issues which cropped up for consideration. Lordships have seen Nagaraj.
Yeah.
My lord, an application for review was filed by the state in Nagaraj,
Yeah.
which was dismissed on 16/11/2016.
Yeah.
My lord, an ordinance which has led to the act in question
Yeah.
was promulgated on 21/1/2017.
Yeah.
And the impugned act is passed on 31/1/2017, deemed to have come into force from 21/1/2017.
21/1/17. Yeah.
So, my lords, the order in review passed on 16/11/2016 is not a non-speaking order saying that we don't find any grounds to review. The order, my lords, the learned judges will not go into the contention, they appreciate the contentions. And then they reaffirm the findings, my lord, given in the main judgment in Nagaraj, but also come out with certain other findings, my lord, which your lordships have seen. Some of them, my lord, I beg to place before your lordships. Point is, my lord, your lordships have always appreciated the difference between adjudicated facts and legislative facts. Adjudicated facts are facts, my lord, which are placed before the court. And, my lords, this honorable court adjudicates on such facts. They have a relation, my lord, to the parties before the court. Parties are heard on them. Conclusions, my lord, are arrived at on facts, saying that it has been established on facts that such and such is the state of affairs. Those are adjudicated facts falling strictly within the relevance, my lord, of an adjudicatory body. And especially so, my lord, they are entitled to a sanctity when the adjudication is done by the highest forum in the land. My lords, the facts which must have persuaded, my lords, the legislature in the earlier instance in 2009 to come out with an act, my lord, are broader. They are legislative facts.
Yeah.
My lord, the challenge to the act in question was predicated on several, my lord, aspects,
Yeah.
including, my lord, repugnancy under Article 254. That, my lords, that this violates, therefore, the provisions contained, it is in conflict with the provisions contained in the Central Act.
Correct.
That this seems to be, the argument of the state seems to be that this practice of Jallikattu is rooted in the culture and heritage of the state, which is peculiar to the state.
Correct.
And therefore, the organization of Jallikattu by itself, the organizing of Jallikattu by itself, cannot be treated as a cruelty, or the participation of the bulls in the Jallikattu as an event, and all such things which take place, my lord, in seeing that such an event is organized, will not amount to a cruelty.
Correct.
Within the meaning of the Prevention of Cruelty to Animals Act of 1960.
Yeah.
My lord, the nature of the animals, their essential characteristics, the fact that they are sentient animals, the fact, my lord, that they are unsuited to participate in an event of this nature, the fact that, my lords, that the actual organization of the event cannot keep at bay, my lord, acts which amount to a cruelty, subjecting the animals to unnecessary pain and suffering, My lord, I use the words because those are the words, my lord, which resound from the reading of the act. This really has been adjudicated upon by the court, and the court says that no, this can't be done. But there is also, my lord, a finding of fact. These are adjudicated facts, my lord, by this honorable court, and it can't go higher than that. There is a reaffirmation of these adjudicated facts, my lord, in the review order. My lord, it's too late in the day, my lord, and I really cannot advance an argument before your lordships that the legislature is not empowered, my lord, to come forth with the law. If it removes the basis of the judgment, if it is otherwise legislatively competent, and, my lord, it does not violate any other constitutional provision, and more particularly, my lord, any provision contained, my lord, in Part 3. The legislature is entitled to step in. It can remove the basis of the judgment. And in doing so, my lord, it therefore exercises a power, my lord, within its competence, provided it is within the legislative competence of the state. My lord, when it is challenged before your lordships will look at it from several angles. Because the challenge is on the ground that it is not competent. Why it is not competent? Because, my lord, it strictly doesn't fall within entry 17 of list 3. A legislation of this nature, by which, my lord, the state brings about an amendment to the Central Act, carving out an exception, as it were, my lord, to the scheme that has been outlined with the Central Act, may not really fall within the competence of the legislature under entry 17. Why? I'll take your lordships to that. Secondly, my lord, if the legislature, when the law is challenged on the ground, that the legislature has usurped the judicial power or has transgressed into a territory which was occupied by the court's judgment, my lord, which has been rendered after hearing both sides, and a detailed judgment at that. Is there any factual material that is placed before the court, my lord, to say that these are legislative facts that have been assimilated by the legislature post the judgment and post the review order, which had persuaded, my lord, the state originally to come out with an ordinance, promulgate the governor to come out with an ordinance, and thereafter, my lord, place it before the floor of the assembly, and then, sorry. Very good. Pleaded, my lord, in support of the legislation which was there earlier, including, my lord, on the preservation of the culture and heritage had been put forth, had been adjudicated upon And thereafter, my lord, they come out with an ordinance within 45 days.
That's right.
Whereas the legislative facts which cannot be gone into by your lordships.
That's right.
But
Therefore,
therefore, my lord, the question is, where is the legislative facts which have been taken note of, my lord, for the government after all, my lord, prepares a bill and then.
That
places
also we
it.
don't think we can prove it.
Very well, my lord, I am not taking it to that. I am saying, my lord, that it may not come within the